Welcome to Legal Minds. This is my first video for the public law module. It certainly will not be the last, and the topic I will be covering is ministerial responsibility. So firstly, it's necessary that you understand what a convention is, as ministerial responsibility is a convention. Now this is an entire topic of its own. There is no set cookie-cutter definition of a convention, but various constitutional theorists have attempted to define it. Marshall and Moody described them as rules of constitutional behavior, which are considered to be binding, but are not laws. And applying that to the Convention of Ministerial Responsibility, we could say that it dictates ministerial behavior and is considered to be binding, but is not legally enforceable. The Oxford Legal Dictionary, which every law student should have, defines ministerial responsibility as the responsibility to Parliament of the Cabinet collectively and of individual ministers for their own decisions and the conduct of their departments. A minister must defend his decisions without sheltering behind his civil servants. If he cannot, political pressure may force resignation. And it provides the case of Carl Toner Limited, which essentially shows that ministers are responsible for the conduct of their department. You also need to understand that the convention is not legally enforceable, which is axiomatic in the case of A.G. and Jonathan Cape, where the courts were not willing to uphold the convention. The trial came about because a certain former minister had publicized ministerial proceedings, which was a convention, and the issue the courts were faced with was whether or not they should uphold the convention or not, and they essentially said they couldn't enforce the convention. So there are no legal sanctions for a breach of the convention, only political ones, and the highest form of sanction for breach of the convention is that of resignation. And paragraph 1.3 of the code also shows that the convention is not legally enforceable. Furthermore, the convention is driven by the Nolan principles, which are also referred to as the 7 principles of public life, and they are contained in the back of the Ministerial Code of Conduct. The principles include selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. So in this presentation, keep these principles in mind and you decide whether or not these principles have been adhered to. If you really want to get an in-depth view of the convention, I would actually read the entire Ministerial Code of Conduct 2010. I printed a copy out myself, read it, annotated it, and I can certainly say that it helped my understanding. It's also worth noting that the code is decided by the government of the day. It's also useful to actually know what a minister is, because it's no good understanding the convention if you don't actually understand what a minister is. Essentially, they lead government departments based on function. So for example, you have the Minister for Transport, the Minister for Education, the Minister for Health, etc., etc. They're drawn by convention from the House of Commons and the House of Lords, and they're appointed by them on behalf of the Prime Minister, and that itself is a convention. Now we shall get on to the meat of the matter. There are actually types of ministerial responsibility. There is collective ministerial responsibility and individual ministerial responsibility. So collective ministerial responsibility has been described as the cornerstone of the political constitution. I like to describe it as the theoretical glue of the government. Why theoretical? Well, because the convention does not always work. It applies to all ministers and requires that they deliberate as a collective voice and body. It also requires them to be collectively responsible for the government's conduct. And this has led to conflict between collective ministerial responsibility and individual ministerial responsibility, oftentimes the latter being suspended because of the former, but that's something we'll come on to later. It also requires ministers to agree with government policy, because if all ministers agree with government policy, then that consensus will augment and maintain collectivism, thus upholding the Convention of Collective Ministerial Responsibility. And if a minister does not agree with government policy, then they are required to submit to the highest political sanction, which is that of resignation. So why does the convention exist? What is its purpose? Well, the idea is that collective ministerial responsibility leads to a strong, well-integrated, coherent government. Without being strong, well-integrated and coherent, the government will lack efficiency. Now, whether or not the government is efficient or not is itself subjective, but the idea behind it is that it helps the government to operate efficiently. It also gives the public confidence in the government, supposedly, as the public can trust ministers to be responsible people, to be responsible for their actions. The resignation of Stephen Byers shows that ministers may also resign to allow for clarity of thought in the government. He resigned not because he felt responsible for the scandal he was involved in, but because he felt that he was becoming a distraction to government. Those were essentially his exact words. Now, as I said a moment ago, if a minister does not agree with government policy, they are required to resign. And I've given 3 examples on the slide, one of those being Baroness Warsi, who resigned because she disagreed with the government's stance on the suffering of the Syrian people. The government took a major hit when she resigned because not only is she a she, but she was a Muslim. So while she was a minister, this was good for their reputation. It gave them the image of valuing equality. And I'm pretty sure she was the first female Muslim minister. And then there's Robin Cook, who resigned because he disagreed with the government's stance on the Iraq war. Now, the resignation of Claire Short is an interesting one, because she actually disagreed with the government's stance on the Iraq war, just like Robin Cook. But instead of resigning at first, she spoke out about it and criticised the government very openly. She initially did not resign, and Tony Blair didn't put pressure on her to resign for 2 reasons. Firstly, it would have been embarrassing to lose 2 ministers on the same issue in the same year. Secondly, she was a woman. Well, she still is a woman, but by having her in the government, again, they seem to value equality. So this is an example of the convention being suspended for political convenience. She did eventually resign because she kept on speaking out and she essentially was taking liberties, so eventually she had to. There have actually been numerous times when the convention has been suspended. In the 1930s, during a coalition government, the Conservatives and Liberal members both took different views in relation to the introduction of protective tariffs. In 1975, Harold Wilson allowed members to disagree in a referendum campaign on EU membership, and this is famously known as the Agreement to Differ. David Cameron himself may actually suspend the convention if there is a referendum on EU membership, because as we know, the Lib Dems are pro-EU and the Conservatives not so much. Sir Jeremy Haywood claimed to have actually overheard the Prime Minister and Deputy Prime Minister agree to suspend the convention in future. And the Coalition Agreement for Stability and Reform actually explicitly allows for the convention to be set aside. And I think that the mere fact that we have a coalition government is relevant to the topic of ministerial responsibility. We have 2 governments forged into one, which both possess radically different views. And can we really have collective ministerial responsibility without collective views? And then there's the Convention of Individual Ministerial Responsibility, which is also contained in the Ministerial Code of Conduct. And it requires individual ministers to uphold collective ministerial responsibility, because in order for the latter to be sustained, individual ministers must commit themselves to the collective. It also requires that ministers remain accountable to Parliament for the conduct of their department, and they must give accurate and truthful information to Parliament. In other words, they cannot lie to Parliament or mislead them, and if they do so by mistake, then they need to correct that error. If they knowingly mislead or lie to Parliament, then they are required to resign. It also requires that ministers should be open with Parliament and the public. Now let's talk about when individual ministers would be required to resign to uphold the Convention of Individual Ministerial Responsibility. Firstly, a minister would be required to resign if they are responsible for some sort of departmental error. So there's the Crichel Down affair, where a piece of land had been taken from the original owners during wartime, so it could be used for Royal Air Force practice. And Churchill promised to give the land back to them, but a minister, Thomas Dugale, rented it out and eventually had to resign for doing so. There's also the example of Lord Carrington, who resigned after his department failed to respond to intelligence reports relating to the Falklands invasion. A minister must also resign if they mislead Parliament in some way. As I said earlier, Stephen Byers allegedly misled Parliament in his part of making a railway company bankrupt, and because other ministers felt he misled Parliament, they pressured him to resign, and eventually he did. But it's worth understanding that he actually denied responsibility and accountability, and he resigned not because he felt responsible, but because he felt that he was becoming a distraction to the government. John Profumo resigned after allegedly lying to Parliament. Jeremy Hunt allegedly lied to Parliament in relation to his involvement with the Murdoch affair, the phone hacking scandal, and he actually didn't resign, so that's an example of the convention not being adhered to. Although he said he did consider it, he did not actually resign. The convention also requires ministers to resign if they acted dishonestly or inappropriately in some way. So David Law resigned after making excessive expenses claims. Chris Hun, or Chris Hoon, not sure how to pronounce it, resigned after persuading his wife to take speeding tickets or points for him. Edwina Corrie resigned after claiming that all eggs contain salmonella, which they don't. And there's the fairly recent example of Andrew Mitchell, who resigned after calling a policeman a pleb. Estelle Morris, former Minister for Education, resigned because she did not feel competent enough for the job. So it could just come down to how competent a minister feels. If they feel inadequate for the job, they may resign. But many times the convention does not actually work. There are times when ministers do not resign, even when a departmental error has been made. Earlier on I mentioned Jeremy Hunt, for example. Another example would be the Scott report, which largely criticised ministerial behaviour in relation to the Arms to Iraq affair, where there was evidence that the government supported a company in the UK selling weapons to Iraq during the Iraq War. Yet no minister actually resigned when they were supposed to. They essentially misled Parliament by not providing adequate information, so it was a concern to democracy. Although now it is harder to mislead Parliament, as following the Scott report, a revised code of practice was introduced. Theresa May is another example. She was involved in the border control fiasco and blamed the civil servants, and they were sacked. So she essentially deflected responsibility by blaming the civil servants. Now, if you remember at the beginning of this video, when I made reference to the Oxford Legal Dictionary of that definition of ministerial responsibility, I said that ministers are not supposed to hide behind the civil servants. Well, that's exactly what she did. And oftentimes a minister will actually use the media to leak information rather than resigning, which is a good thing and a bad thing really. It's good for the public as they know what's going on, but it can be bad for public confidence, however. And it's also bad for the convention because it means that it's not being followed. As I said earlier, Claire Short went to the press to voice her disagreement on government policy, and she did so before resigning, even though the convention requires that if you're going to speak out against policy, you must resign first. It's also the Prime Minister's job to pressure a minister to resign, and they are not as likely to do this if the minister is well respected or valued, which is essentially why in 1992 John Major didn't pressure David Mellor to resign following a sex scandal that he was involved in. Eventually he did pressure him to resign, but it was over something else, something irrelevant to the sex scandal. If he didn't pressure him to resign following another incident, then it would probably have damaged his own reputation. The convention of ministerial responsibility often comes under a lot of criticism. The convention and the way it's exercised comes under a lot of criticism. The Nolan Committee suggested that the Prime Minister should determine a clear code of conduct for ministers to adhere to in their personal lives rather than bestow arbitrary rules of behaviour on them. And following the Scott report, it's been suggested there should be a higher level of ministerial accountability and a stricter need to answer parliamentary questions. If you remember that I mentioned in relation to the Arms to Iraq scandal, ministers didn't provide adequate information to Parliament. And part of the problem is that ministers don't actually have to answer questions on matters of national security and foreign affairs. The Hutton inquiry suggests that ministers avoid responsibility and accountability, which makes it harder to pinpoint exactly what happened in a scandal. Perhaps ministers should be held responsible and accountable if they're involved in a scandal, regardless of blameworthiness. One issue is that collective ministerial responsibility can often prevent individual ministers from remaining accountable. So the Butler report, for example, absolved all individual ministers from responsibility and accountability relating to the intelligence failures of the Iraq War. It is also said that the convention only applies to policy matters and not operational ones, which are often taken on by the civil servants. The case of Williams in Home Office Number 2 shows that failures of the civil servants are not regarded as ministerial acts. This is a problem in a way because it allows ministers to blame the civil servants. James Pryor, for example, blamed the civil servants for incompetences relating to a report of the Mays prison escape and essentially deflected the blame. This was also what Theresa May did over the border control fiasco, if you remember that I mentioned that as well. So that's ministerial responsibility covered. In future, I will be doing more videos on the topic. I will be discussing current issues that are in the media, and I think I'll make another video actually based on when the convention has been adhered to, because a lot of what I spoke about in this video was when the convention hadn't been adhered to. So I think what I'll do in the future is I'll make another video giving examples as to when it was actually adhered to. So thank you for listening. I hope you gained something from it. Don't forget to like, share, subscribe, and check out my other videos.